The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning, everyone, and welcome to this remote oral argument session of the North Carolina Court of Appeals. We have two arguments on the calendar this morning. The first is number 2273, State versus Lance, and we've confirmed the parties are ready to proceed, so we'll hear from the appellant.
Good morning, Your Honors, and may it please the court. My name is Warren Hinson. I am counsel for appellant Sherry Lee Lance, and I would like to reserve 5 minutes for rebuttal. For centuries, it has been held under common law that one could not be guilty of arson for burning one's own dwelling house. This is because, as in North Carolina, common law arson is defined as the willful and malicious burning of the dwelling house of another person. The operative words here being of another person. The question presented in this case is whether a dwelling house solely inhabited by two alleged co-conspirators to commit arson constitutes a dwelling house of another for purposes of common law arson. Case law from our state Supreme Court and from jurisdictions around the country going back hundreds of years make it clear that the answer to this question is no. Courts and scholars have recognized that the common law of another requirement meant that the dwelling had to be in the possession of someone other than the incendiary, a fact which this court acknowledged or recognized in its decision of State versus Ward in 1989. In this case, the evidence showed that the only people residing at the dwelling house in question on the date of the fire were Mrs. Lance and her mother, Johnny Turner, the other alleged co-conspirator to commit second-degree arson. The state contends that because the other co-conspirator, Mrs. Turner, also lived at the dwelling house at the time of the fire, or on the date of the fire, this satisfied the of another requirement. But the state's argument is an invitation to stretch the meaning of another beyond its legal and logical limits. Specifically, our Supreme Court has recognized that the main purpose of common law arson is to protect those who may be inside the dwelling that is burned. It is the crime that is focused on the security of habitation of those who might live or might be in the dwelling. As the case law shows, it's designed to protect the unwitting and innocent co-occupants of a home who are without advance notice of a fire, who are unaware of its impending dangers. On the other hand, co-conspirators, by definition, have agreed upon the arson to be committed, and inherent in which is a meeting of the minds, some degree of planning and coordination.
Counsel, let me ask you a question about that. I want to understand your argument here. So, one common plot point in heist movies is this idea we'll light a fire on one side of town and all the emergency personnel and the police will respond to the fire, and then we'll rob the museum and steal a bunch of antiquities while everyone's distracted. So imagine a defendant who goes to a co-conspirator and says, I'm planning this heist, so I need to light this fire. Can you get me gasoline and matches and everything I need to start the fire? And the co-conspirator says, absolutely, procures all the necessary incendiary materials. Then the defendant lights the fire. When choosing where to do it, the defendant chooses the co-conspirator's home and lights that on fire, and then goes and commits the heist at the museum. Is your argument that, and this co-conspirator had no idea, and suddenly her home is on fire and she's rushing out to avoid burning alive, is your position that that's not arson?
If I may ask a clarifying question, and maybe I missed it in your hypothetical, does the co-conspirator and do the two co-conspirators live in the same dwelling, or is the co-conspirator living at a different dwelling?
Just the co-conspirator has her own home. It's a completely separate. It just happened to be the one the defendant burned down, but she's definitely a co-conspirator in the plan to burn the home down.
Well, I guess what I would say is if it's not the dwelling of the of the arsonist, then it wouldn't be arson, which is different from the facts of our case, which is they were living in the same home and they were part of members of the same dwelling house.
Well, so that was my next question is, suppose then that it happens to be the home that they share. But again, the co-conspirator had no idea that the home was going to be burned down. Do you still rest on the position that it was your argument then that that makes it different and now it's not an arson?
Well, I just think that under the common law, if you have people living at the same dwelling, you cannot legally or definitionally commit arson against your own dwelling, your own home. And so I would contend that it still would be it would not satisfy the common law requirement there.
Okay, so do you see where I'm going with the questions though? Is your argument that the emphasis is on the person, the co-conspirator being aware that of the particular home is the one that's targeted to burn at the time that the conspiracy is formed, or is it just the idea that anyone involved in the crime, their home it cannot be the home of another? What's your argument there? Or where do we draw that line?
Well, I think you have to look at the purpose underlying the common law arson, which is to, as it says, to protect the habitation of those who live or might be involved in the dwelling. And if you have facts that, like in this case, show that no one's habitation was endangered, no one was anywhere near this fire, then I don't think it satisfies that requirement. It doesn't meet the purpose that the common law has established. There are other recourses here for the state, but in
So, Mr. Henson, let me ask a question about what you just said. So is it your contention that because no one was in the home at the time of the arson and they were co-conspirators, that therefore they couldn't be guilty of the crime of arson? But what if one of the persons, part of this conspiracy, was in the home at the time of the fire? Would your position still be the same, or would it be different?
If one of the members of the conspiracy was at home at the time of the fire? Well, I guess it would depend on the exact charge. If it's, again, second degree arson, no one is home, it's second degree. If it's first degree arson, someone is home. That's under our, statutes of first and second degree arson. And I think that there is, you have to, I just don't think that the common law arson here, it meets those requirements in the facts of this case. I don't, I'm not sure that if you have co-conspirators, who are, somehow the plan doesn't go accordingly, and maybe in a different case, there might be some distinction, but here, I don't think that you have any of the risks that the common law was concerned with, and I don't think that that the facts of this case meet the legal definition of the crime with which they were charged.
But I think that's what Judge Wood is getting at, is how are we, so are you arguing that you look at the facts of every case and decide, was there any risk that if the co-conspirator was not participating in the actual lighting of the fire, we're engaging in some sort of fact analysis about how dangerous it was to that co-conspirator in a particular case to determine whether or not it can be an arson case? That seems like that's not how criminal law ought to work.
I agree. That is an unwieldy analysis, in fact, intensive analysis, not suitable for an appellate court to make on a case-by-case basis. I think that if you look at the definitions of co-conspirators, and there's some agreement, express or implied, to commit a specific crime, and the crime of arson. I just think that there is, the law envisions some degree of agreement, but to commit the crime. And so far, I think the case law has would support the fact that if we're concerned about innocent, unwitting parties being endangered, to me, this does not apply itself to the co-conspirator situation. But
why would the law care if that other person who's endangered is innocent or not? Couldn't it be that the law is intended just to ensure that, to punish any situation where that danger is created to some person other than the defendant who's committing the crime?
Yes, I think that that's consistent with our case law saying, we are seeking to protect the safety of those who reside in the dwelling, which is the purpose underlying the crime. I just think in this case, the facts here are show that there was no risk posed to the co-conspirator who was specifically charged with and pled guilty to conspiracy to commit second-degree arson. They weren't anywhere near the home at the time that this fire occurred. And the state, this concern was never expressed in the trial court. And on appeal, now we're saying the state is contending that it was, expressing some dismay or concern about the co-conspirator. And I'm not sure that there was, seems like trying to have it both ways, but I would just say that the facts here, they don't indicate and they don't show that there was any degree of risk posed to Mrs. Turner, the co-conspirator, or Mrs. Lance, the two sole residents of the dwelling. And there was evidence to show that this was quite a coordinated situation between the two of them, and that neither of them were in any harm in terms of being in harm's way in this case. So if it was a legal impossibility, as we contend in this case, definitionally speaking, for Ms. Lance to be convicted of second-degree arson, then we also contend it was a legal impossibility for her to be guilty of conspiracy to commit second-degree arson, because by definition, there would have been no unlawful act to have been agreed upon between the two co-conspirators who were indicted for conspiracy to commit the specific crime of second-degree arson. And finally, with respect to the insurance fraud charge, we did file a memorandum of additional authority citing the case from this court of State versus Massey for the principle that an insurance fraud charge that is inextricably interwoven in with the other two charges, the conspiracy and the arson charge, that the insurance fraud charge should fall with the other two. And that is the principle that the holding that is at the end of that short decision that we filed as a memorandum. So to be clear, the state was not without recourse for prosecuting Ms. Lance for her alleged conduct. As indicated in our brief, the state simply charged the wrong crime. And in seeking to uphold this erroneous conviction, the state is asking this court to stretch the purpose and meaning of common law arson beyond what it has meant for centuries. And this court should decline to do so. And based on the particular facts of this case and the specific definition of common law arson, we would ask this court to vacate her convictions for common law arson, second-degree arson, conspiracy to commit the same, and insurance fraud. And if there are any other further questions with respect to this issue, I would like to turn to the second issue in our brief.
Mr. Hinson, I got a couple questions for you. Who decides whether or not there's a conspiracy?
I'm sorry?
Who decides whether or not there's a conspiracy? The jury, right? The jury, correct? Sorry?
Who decides if there is a conspiracy?
Yeah, it's a question for the jury, correct?
Yes.
I mean, you have the allegation, the jury determines whether the facts have been proven. So up until such time as the jury determines that there is a conspiracy, the issue raised on appeal is that the court erred by dismissing the case of arson against the defendant at the close of the state's evidence. Jury at that point had not made a decision as to whether or not a conspiracy had existed. So why would it be erroneous to send that to the jury for the jury to make a determination as to whether or not a conspiracy existed?
Well, our contention, thank you for the question, Your Honor. Our contention would be that it should have been dismissed by the trial court before it reached the jury, because the evidence given the evidence and the definition of conspiracy to commit second-degree arson, that there could have been no unlawful act to have been agreed upon, and the evidence was insufficient as a matter of law to support the charge to even get to the jury. So our contention is a sufficiency issue.
So say the jury agrees with you and they say, we don't think there's any conspiracy here, then the jury could lawfully convict the defendant of arson, correct? Even under your theory.
I don't think that the jury could lawfully convict Ms. Lance of arson under the facts of this case, no.
Well, your argument hinges on whether or not there were co-conspirators involved sharing the residence. If the issue goes to the jury says there's no conspiracy here. That takes out the co-conspirator element. Why could the jury not then lawfully, even under your theory, lawfully find the defendant guilty of arson?
Well, because if you take out the co-conspirator element, there are no other people residing in the dwelling house besides the defendant at the time of the fire. You can't have arson.
I thought that unless I misread the briefs, the residence was actually was the residence of the mother and the daughter, who is the defendant in this case at the time.
Correct. No, you're right. I'm sorry, I misunderstood your question. Yes, they were both residing there, the two of them, on the date of the fire. And so I guess if I understand your question, you're asking if the mother were not a co-conspirator, would this have satisfied the arson requirement?
The jury determines whether or not there was a conspiracy at all. Your issue on appeal is that the court should have dismissed the case at the close of the state's evidence and not sent it to the jury. That's the argument that you're making in your appeal.
Correct.
My question is, if ultimately it's the jury's call as to whether or not there's a conspiracy, if it goes to the jury says there's no conspiracy here, why can then the jury not convict the defendant lawfully, even under your theory of arson? Is that,
Yes,
am I just confusing you? Because that's
no,
possible.
I guess I just that's not what happened in this case.
I understand, but we're not viewing your case as of at the end of the trial. It was erroneous for the court to enter these judgments. The issue on appeal is that it should have been dismissed at the close of the state's evidence.
Correct.
Okay.
I mean, to follow up on that, I think the point Judge Carper's making is that is the wrong thing preserved and appealed here. So, for example, would the correct way to handle the argument that you're making have been to, after the jury returned its verdicts, seek to arrest judgment on the
Okay,
arson claim, for example, because you can't have the conspiracy and the arson. In other words, you understand what the question he's asking is at the
Yeah.
sufficiency of the evidence stage, we don't know if there's a conspiracy. There's some evidence of that, but it may be rejected by the jury.
I thank you. I understand what the question at this point, and I guess my is whether they are mutually exclusive propositions, perhaps, is one way of considering it. Whether, if you could have, if the jury found not guilty on conspiracy, but could you have guilty of arson?
It's sort of twofold, Mr. Henson, and I know I'm consuming a lot of your time, and I don't want to steal your opportunity to argue away from you. But basically, it's the way I see it, or as I'm proposing it to you, is that this information could have gone to the jury. The jury could have found the defendant in this case not guilty of conspiracy and lawfully guilty of arson, even under your theory. Or if then the question becomes, is it a post-judgment issue where you have the legal impossibility? If they find conspiracy, then you can't have the arson. But that's not the issue that's being argued on appeal. The issue that's being argued on appeal is whether the court erred in not dismissing the case at the close of the state's evidence. Does that make sense?
Yes, I understand the question now. The argument that we did raise was the sufficiency issue. That's what we briefed with respect to both of those. If you were to consider it as, as a matter of law, after the jury returned the verdict, should it have arrested judgment because it's legally impossible or inconsistent with the definition of arson and the facts of this case? I would agree that would be appropriate.
If we accept your argument wholesale, then if the jury convicts of conspiracy to commit arson, then it's a legal impossibility for her to be convicted of anything, correct?
Of the two charges that were charged in this case.
Correct. Yes. Okay. All right. I think I understand your position. But we're talking about the court erring at the close of the state's evidence to dismiss charges is what's being addressed on appeal. So I'm sorry I confused you, and I probably should retain Judge Dietz as my interpreter on questions to go with me and explain things for me. Go ahead, Mr. Henson. Sorry to consume your time.
Okay, so I'm going to turn to the Rule 702 issue, the second issue raised in the brief. And the question before this court is whether a trial court's failure to conduct a proper Rule 702 analysis, which allows into evidence unreliable expert testimony that has been repudiated by the scientific community, constitutes a prejudicial abuse of discretion. So, and the answer to that question, based on the specific facts of this case, is yes. When exercising its gatekeeping function to determine the admissibility of the state fire expert in this case, Casey Silvers, who was retained by the insurance company, the trial court failed to conduct 2/3 of the three-pronged reliability test under Rule 702. It did not conduct any analysis as to whether the testimony was the product of reliable principles and methods, and it did not determine whether the witness had applied the principles and methods reliably to the facts of this case. The trial court only addressed the first prong of Rule 702's three-part reliability analysis. By definition, that cannot be the result of a properly reasoned decision, and it constituted, therefore, an abuse of discretion. And now the question is, what is prejudice, and how would Ms. Lance have been prejudiced by this decision?
Well, counsel, is your position that because the court didn't expressly say, here's my thinking on these prongs of the test, that the court actually just never engaged in any consideration of them? Is that what you're saying?
I don't think there was no express acknowledgement of those factors, and I don't think there was any implied recognition of those factors. She mentions facts and data, which goes to the first prong of the three-prong reliability analysis, but I don't think that the record here supports even an implicit finding as to whether the methods and principles were reliable and reliably applied.
Well, Mr. Henson, didn't your client's attorney withdraw the motion to disqualify and then say he wasn't going to object to Mr. Silver's testimony?
He initially made a motion to disqualify based on the fact that he thought there was a conflict of interest because the investigator had been retained by the insurance company, but they did object during the hearing on Daubert grounds, on 702 grounds. And so in respect to the prejudice issue, the failure to conduct the proper Rule 702 analysis permitted the introduction of evidence pertaining to a theory known as negative corpus, which has been discredited by the pertinent scientific fire community. And the National Fire Protection Association, and this is referenced in our brief, the NFPA, which is considered the gold standard or standard of care by courts and experts, concedes, or it asserts, that this method is inconsistent with the scientific method. And it's a method that, simply put, it takes the process of elimination one step too far. It not only eliminates hypotheses about the cause of a fire, but then it claims to establish a single remaining hypothesis about the cause of the fire, even if there's no direct evidence to support it. And here, this is what the state's expert used in his approach. He started with the hypothesis that the fire was intentionally started. He considered and excluded alternative bases that could support that hypothesis, such as electrical failures, unattended cooking, smoking materials. And after eliminating all those other possible theories, he was still not able to alternatively explain his hypothesis that the fire was intentionally set. And so he concluded he could not exclude an incendiary cause. And on page 206 of the transcript, he concludes in his testimony to the jury, "I proposed a hypothesis that this was an intentionally set fire. I tried to disprove that hypothesis by coming up with alternative explanations as to what I was seeing. And based on the science and data I observed, I was not able to alternatively explain that, and I could not exclude an incendiary cause." Now, the trial court itself was very confused, or not confused, it was concerned that this was confusing testimony. And specifically, at the end of the voir dire, before Mr. Silvers was permitted to testify to the jury, the trial court said, I do not want to confuse the jury. We also don't want to give them a false impression of what this expert's testimony means. Specifically, what's concerning to this court is when he said what he means by causation is this is what it means. That's not what it says. What it says, he could not exclude it. That's much different than saying that's what this means. And I want it very clear that he just couldn't exclude by his scientific means, not that that means that this is what happened. And if the trial court is that confused by what his testimony may mean, it's disconcerting and not unreasonable to infer that the jury may have been confused by this expert's testimony as well. And the trial court said it was going to give a limiting instruction to the jury to this effect on what exactly the expert's testimony means concerning causation. The trial court unfortunately never gave that limiting instruction. They just gave the pattern jury instruction, which did not speak to any of these specific issues. So, aside from the expert's testimony in this case, the state's evidence of Ms. Lance's guilt for intentionally starting the fire was far from overwhelming. It consisted of circumstantial secondhand statements from two witnesses, and neither of them were anywhere near the residence or around it at the time of the fire. To prove its theory that Ms. Lance intentionally started the fire, the state heavily relied on the expert's testimony, and it lent the state's case an illusion of scientific rigor based on a method that is scientifically unsound and that has been repudiated by the pertinent scientific community. And absent this erroneous expert testimony, there is a reasonable possibility that the jury would have returned a different verdict. And therefore, under this second claim, this court should grant Ms. Lance a new trial. Thank you.
All right, thank you, counsel. We'll hear from the state.
Good morning. May it please the court? My name is Tom Felling. I'm an assistant attorney general with the North Carolina Department of Justice, and I'm here on behalf of the state in this matter. This case involves a defendant who, along with her mother, the day before the home is on video, the day before her home burns, is on video and gate access registers, accessing a new storage unit to unload valuable personal possessions and mementos into that leased storage unit. And this also occurred on the day of the fire as well. And then defendant is next seen on video at the storage unit almost immediately after being contacted by law enforcement investigating the arson in this case. But most crucially, this case involves a defendant who indicates to a witness that she set fire to her own home and who admits to her own father that she burned her own home for the purposes of collecting insurance proceeds. On the first three issues briefed in this case, I will discuss how the actions of the trial court were proper such that there is no error on appeal. On issue one, the trial court properly denied defendant's motion to dismiss and thus did not err because at trial, the state presented ample evidence against the defendant on all the essential elements of the crimes of second-degree arson and conspiracy to commit second-degree arson. Defendant's argument that the dwelling house in question does not qualify as the dwelling house of another for the purposes of second-degree arson is not supported by the current controlling precedent of this state. Simply put, a co-conspirator is someone other than the defendant. And when a co-conspirator resides with the defendant in the home is the dwelling house of another because someone other than the defendant resides there. Common law arson is defined as the willful and malicious burning of the dwelling house of another. And by statute, the offense is arson in the second degree when the dwelling burned was unoccupied at the time of the burning.
So, counsel, if two people who live in the same home both together burn their house down to collect the insurance proceeds, and they're tried in two separate trials, can they both be charged and convicted of arson because the other defendant that participated in setting the fire is the other for purposes of this criminal charge?
Your Honor, that may be the case because that addresses co-perpetrators as opposed to co-conspirators to a crime. And our case law does acknowledge that a dwelling in possession of someone other than the incendiary, that the dwelling be in possession of someone other than the incendiary for common law arson. So if both are the incendiaries, that may be the case, although that is not implicated in this case because this only deals with co-conspirators and the court need not consider cases that involve co-perpetrators or co-arsonists to the crime because a conspiracy stops at merely the agreement. And in this case, the defendant's mother, there's no evidence that she participated in the actual crime. So I think it's a very important distinction to consider that these are only co-conspirators to the crime and not co-arsonists. So on appeal, defendant argues that the charges against defendant should be dismissed because defendant's mother is not another person for the purposes of common law arson because she's a co-conspirator. And this argument is contrary to the precedent of this state. And defendant is essentially asking this court to deviate from that precedent and set a new standard for common law arson that applies to this current situation. And the premise of defendant's argument relies on dicta from the court of State v. Jones, or the case of State v. Jones, where the court is merely opining that the purpose of the crime of common law arson is to protect, quote, protect against the danger to those persons who might be in the dwelling house which is burned. And this is to protect the habitation of the home by people and not the property. However, this dicta is not part of the essential elements of the crime of common law arson or second degree arson. And defendant is attempting to read this language into the elements of the crime where it does not currently exist. And to do so, and I alluded to this earlier, defendant's argument relies on a false equivalence between co-perpetrators to a crime, which is an entirely different circumstance than we're dealing here, and a parallel attempting to equivocate between co-perpetrators and co-conspirators, where there is such, where that is a false equivalence. So whether an occupant of the home needs protection from the threat of fire is not an element or not a consideration and not a requirement for the state to prove for common law arson. And even still, there's in many circumstances, and even perhaps in the hypothetical that Judge Dietz alluded to earlier, there are many situations where a co-conspirator would need the protection of this habitation because the mere participation in an agreement does not guarantee their safety. And that is because the conspiracy stops only at the agreement and requires nothing further and does not require that the co-conspirator participate in the crime. So
I think your friend for the defendant is suggesting that the line can be drawn. I think I understand one argument is essentially by knowledge, so that if the evidence is that the co-conspirator is aware of the plan, then that eliminates the danger, and then you no longer should be within the scope of this criminal prohibition because the other person is not facing any risk. They're aware that the fire is going to be set and can ensure that they're not in any danger. So why shouldn't we, if it's the obvious purpose is of the requirement, the home of another is that, and not your own home, is you don't want someone else to be injured in the fire, then why shouldn't we look to see whether that other person who's participating in the crime was aware the fire was going to occur?
right. And I think that the purpose for common law arson as stated in the case law is dicta for this court to consider. I think it gives the reason for the crime of common law arson, but it does not require or create a requirement for the state, especially on a motion to dismiss standard, which is what's before this court today. It does not create a standard of proof for the state to show. Then in addition to showing the elements of the crime, to also prove that any other occupant in the home, in addition to just being someone other than the defendant, was also innocent or unwitting or unknowing that this was going to happen. The precedent in this state does not support that position. And I think to illustrate that, I think that situation, if that's where we went, would create a difficult situation for prosecutors and for the courts to have to prove additional factors to a crime. It might be so fact intensive and so fact specific that that we're really moving away from the of another requirement as it currently stands for common law arson. But I would like to illustrate the state's position with a hypothetical and show the difference between mere co-conspirators and co-participants to a crime. And I think it's important for the facts of this case. So let's picture a scenario where person A and person B live together, and person A and person B agree in the year 2021 to willfully and maliciously burn their home at some point in the future, let's say 2022. They are now co-conspirators to the crime of second-degree arson, or just to arson. Perhaps they don't know whether it's going to be occupied at the time of the burning. The conspiracy is complete at that point. Let's consider a number of possibilities that person B has, where perhaps they have a change of heart and don't express the change of heart to their co-conspirator, but they just have decided in their own head, I will no longer participate in this crime. Perhaps they even remonstrate and actively tell person A, please do not burn our shared home down. I no longer want that to happen. Or perhaps the person it's not either innocent or guilty. The person just kind of forgets about the conspiracy. It's been a long time since 2021. It was kind of a hazy year. They forget when 2022 arrives on the fateful day. By a sheer stroke of luck, person B is not home at the time that person A sets fire to their shared home. But for person B's luck, they would have been home, perhaps injured or killed in the fire because they had no knowledge or understanding that it would have occurred that day. Person A, by the current precedent in this state, is guilty of second-degree arson. And the fact that there was a prior agreement between the co-conspirators is irrelevant to the fact pattern and a determination as to person A's guilt for second-degree arson. And we should also be concerned about the habitation of person B, because but for their sheer luck, they might have been home. And their mere agreement to participate in this crime at some point prior was no indication of no guarantee of their safety. So if the purpose of this crime is to guarantee the safety and habitation of the home, being a mere co-conspirator still satisfies that the reason for this charge in multiple circumstances. Because under the current case law, the dwelling house of another is satisfied by the circumstances in this case where a cohabitant agrees to burn down the home that they share with the perpetrator, the trial court did not commit error that warrants reversal by this court. And on this issue, the state would ask that the court uphold the conviction of the defendant on that issue. Unless there's other questions on issue 1, I do plan to turn to issue 2.
Mr. Felling, take a minute, if you will, and for example, your hypothetical, say the co-occupant of the house did in fact enter into the conspiracy. You get into 2022 on that fateful day, say it's March 9th. On January 31st, co-occupant goes and buys the gas that they're going to use to start the house with, puts it in the outside shelter. All other facts being equal or being the same as from your hypothetical, the house ends up getting burned. At that point, they've acted in concert to carry out the act. See, the issue is larger than just this case, because this will set precedent on this issue going forward. We don't have any case law on this that I've seen. So we've got to sort of flesh out the co-conspirator position that's been addressed by Mr. Hinson versus the potential fact scenario where we have an acting in concert where they're both principals. Co-conspirators are actually sentenced at a one level lower than the principal. You know this. I'm not telling you anything that you don't know. And it's reflected in the judgment in this case that they were sentenced she was sentenced for the conspiracy at one level lower. But in regards to the acting in concert where they're both treated as principals. So give me your thoughts on that. It's not an issue that's being addressed directly in the case and it's not briefed, but it's an issue that I can foresee coming up in the future. And if we can get your thoughts on it, that would help me in my thinking.
Thank you. I think that it's important always to distinguish between the co-conspirator and the co-perpetrator, and whether if the acting in concert theory is equivalent to them being co-perpetrators to the crime, and the evidence would show that their actions were the equivalent to them both being the incendiaries, then conceivably the case law showing that the dwelling must be in possession of someone other than the incendiary to qualify for common law arson, I could see an argument where those two persons acting in concert, if they are both considered the incendiary, would be distinguishable from this situation. So I hate to speculate, but it may be possible for those individuals for it not to be common law arson in that case, if they are both considered the incendiary. I would urge the court not to consider those facts and not consider it for the purposes of this case, because this is only, the facts of this case only apply to co-conspirators where there's no indication that they acted in concert beyond the agreement. The state's theory of the case in this case was that the defendant acted alone in the arson, in being the incendiary to the home. So I think as difficult as the issue is in this case, considering broader ramifications for co-defendants or on a theory of acting in concert, might be more than the court should consider in a narrow ruling in this case.
But you can see the tension that Judge Carpenter is pointing out in his hypothetical. If you took a number of acts that meant you're a principal in committing the crime, but then have the change of heart and you're in the home when your other co-perpetrator sets the fire, it certainly seems like the type of conduct that we would want to say is arson, because that second person who had the change of heart their life is at risk. The home is lit on fire, and so it seems odd to draw the line at a distinction between co-conspirators and co-perpetrators. But then that gets back to my question about, is it really so fact intensive that in every case we need to be asking questions in some sort of doctrine about how much the other person, the other inhabitant of the home knew about the crime and how much they participated in? That seems like an unwieldy standard.
Thank you, Your Honor. Let me give a clear response to those issues. That where the state is required to prove that the home is the dwelling home of another, that is a person other than someone else who is also an incendiary. That is the requirement, to show that the state merely needs to prove that the dwelling home burned is the dwelling home of someone other than the defendant. If the case law shows that the dwelling must be in possession of someone other than the incendiary, if there's two people who are participating in the arson, that is a different circumstance. There needs to be no fact-intensive inquiry for common law arson among co-conspirators. Under our current precedent, it is a simple question. If and this is what the jury is instructed on, the pattern jury instructions say, the dwelling home is the dwelling home of someone else when it is in possession of someone other than the defendant, and the inquiry can stop there. I'd now like to turn to issue 2. The trial court properly denied defendant's motion to exclude the testimony of Casey Silvers, the state's expert, and thus did not abuse its discretion because the trial court, after hearing adequate foundation testimony, based its ruling on the factors set forth in Rule 702A of the North Carolina Rules of Evidence. There was no evidence presented at the motion hearing or at trial to demonstrate that Mr. Silvers used a disfavored technique known as negative corpus. The trial court heard foundation testimony regarding Mr. Silvers' qualification as an expert, both on voir dire at the motion hearing and during the preliminary foundational testimony at trial prior to the state's tender of Mr. Silvers as an expert. And the court is well aware of the 3 parts of 702A. And I wanted to respond, the majority of this argument is focusing on the 3rd part, the 3-prong reliability test. And there was a statement by counsel for defendant that the court stopped at the 1st prong, and because of that showed that the court was unaware of the other 2 prongs of the 3-prong reliability test. However, if you look at the court's ruling in the trial transcript on page 160, the trial court says, 3, under the 3-prong reliability test, the court is very specifically speaking not to the 1st part, and I'll stop there. That mere statement of the court showing that mentioning, explicitly referring to the 3-prong reliability test shows that the court was aware of the proper standard in this case. And in fact, on appeal, trial judges and trial courts are entitled to a presumption that they are aware of and are applying the law correctly. And that is certainly supported in this case. The fact that the trial judge did not make explicit findings of fact referencing rule prong 2 and prong 3 was not fatal to the court's admission of this expert testimony. It does not show that the court abused its discretion. In fact, under State v. McGrady, the trial court is given wide latitude in applying Rule 702, and Rule 702 under State v. McGrady does not require the trial court to make explicit findings of fact. There is no rigid application to Rule 702. The only requirement is that it be applied when the trial court is ruling on the admissibility of expert testimony. So I think if under an abuse of discretion standard of review, it's important for this court to determine what evidence the court heard in support of prongs 2 and 3 of the reliability test, and whether there was a sufficient basis for the trial court to determine that these prongs were satisfied by what the trial court heard. So in support of prong 2, that the testimony was the result of reliable principles and methods, the trial court heard that evidence that, and Mr. Silvers testified extensively regarding his uses of the scientific method as his method of investigation. He explicitly testified that he uses and applies the scientific method. He testified that he uses the scientific method where he first develops origin and cause hypothesis for all potential causes of a fire. He designs experiments to test those hypotheses. He collects data, verifies data, and interprets data, and then uses that information to reach a conclusion. So he testified that his method for fire investigation is the scientific method, and that NFPA 921 is a guide for the application of that method. So he's using the scientific method, not NFPA 921. NFPA 921 is a guide that instructs arson investigators on how to properly conduct a scientific examination of a scene. He gathered data, reports, witness statements, physical evidence. He made observations at the scene. He performed scene reconstruction. He used reliable approaches that he described as arc mapping, electrical circuit analysis. He described his use of fire science, material ignition temperature points, observable things that are observable to him, such as burn patterns, ventilation patterns, smoke patterns. All of this information and was methods and data that he uses to then test hypotheses to either prove them or disprove them, and eliminating them from, if they are disproven, eliminating them as a potential ignition source. So his testimony was essentially unchallenged and was sufficient for the trial court to determine that his methods and his testimony was going to be the result of reliable principles and methods. There was substantial evidence presented in duplicate, essentially, to the trial court on this prong. We turn then to the third prong of the reliability test. The trial court must be satisfied that the witness applied the principles and methods reliably to the facts of this particular case. So again, while there was no explicit ruling from the trial court on prong 3, there was no requirement of such. So trial court heard testimony that he performs detailed inspections and investigations of the scene. He gathers fire reports, weather reports, takes pictures, takes witness statements. He methodically examines the outside and then the inside of the home in a methodical manner that he described on how he did that. Along the way, he's making observations and taking notes. He did that in this case. He sifted through the debris in this case, the fire debris, the layers of it in a careful, methodical manner, and observed different objects in that layering. He collected test samples. He examined the electrical service to the home, the branch circuits to the home, conducted arc mapping. He examined the appliances, looked for signs of forced entry, examined burn patterns and ventilation patterns. I can go on and on. But this was sufficient for the trial court to determine, and thus it was not an abuse of discretion, that he applied these principles and methods to the facts of this case to reach his conclusion. So there's no indication that the trial court abused their and misapplied the gatekeeping function. And I'll go briefly to the issue of negative corpus.
Let me ask you a question before you move too far from where you are, Mr. Felling. In regards to Mr. Silver's testimony, he testified that he used the scientific method, and then he described what that method was. Of interest to me was his hypothesis formulation was that he formed the hypothesis that the fire was intentionally set, thereby putting himself in a position to prove the negative, versus him traditionally, I would think the hypothesis would be the fire is not traditionally set, and then try to prove the positive that it was. So that, as it relates to the scientific method that was employed, proving the negative versus proving a positive, any thoughts or comments in regards to that application of the methodology?
Yes. So I think in addition to that hypothesis that it was intentionally set, he also proposed other hypotheses that it was accidentally set for a number of reasons, being discarded smoking material, weather factors. So I don't think he had reached the conclusion there and zeroed in on that. He was able to disprove the other accidental causes. But his method for elimination of hypothesis is the method recommended in NFPA 921, where it specifically says, well, the NFPA 921, if you read it in the brief, specifically recognizes that the elimination method is a valid basis for fire investigations. So it was not an improper application of 921 to propose hypothesis and then to either prove them as true, thus confirming an ignition source, or disproving it, thus eliminating it as an ignition source. So I'm not concerned by the method of that in regards to that particular hypothesis. It's supported by NFPA 921. But NFPA 921 also defines negative corpus as a method of identifying an ignition source by believing to have eliminated all other ignition sources. And that's not what happened in this case. His conclusion was only that he could not disprove an incendiary cause and thus he left the cause of the fire as undetermined. His testimony was that the fire cause was undetermined and he could not classify the fire. This is not negative corpus. Negative corpus is when you take your remaining hypotheses, disproven or not disproven hypothesis, and then concluding because that's your lone remaining hypothesis, that must be the cause of the fire. He did not do that in this case, although there was some evidence that supported perhaps that conclusion. He did not do that in this case and thus did not use the disfavored method. It's also important to note that the court did not, there was no learned treatise presented to combat or disprove Mr. Silvers' testimony at trial. It was just his testimony on this issue. So if we're reviewing this on an abuse of discretion standard, I think a lot of the non-legal sources presented in defendant's brief that are purportedly authoritative on the issue of fire science should not be considered by this court because they're not properly before the court. They're not properly included in a brief, or they weren't considered and as part of the record in the trial court. If we're reviewing this through the eyes of the trial judge, we should not now consider that information to cast doubt on the trial court's determination. Even if the court could, or the defendant could show that this was error, it's not prejudicial error. There was other substantial evidence of defendant's guilt that even if it was error to exclude the portion of Mr. Silvers' testimony relating to the cause and not the origin of the fire, that admission of that testimony is not prejudicial because you have just compelling evidence through multiple witnesses of her guilt. So I'll be brief on that. I would like to, before I turn to issue 3, which I think it's important to discuss for the state's purposes, I would like to give the panel any time to ask me any other questions before I move to that issue. So on issue 3, the indictment conformed to the material aspects of the jury charge on insurance fraud such that there was no fatal variance. And the trial court did not err in their instructions on this crime. Because the defendant did not object to the instruction at trial, the court reviews this for plain error. And at issue is the nature of the statement made by the defendant to the insurance company. Defendant contends that this case is very similar, factually similar to the case of State v. Locklear. And I think it's important that I explain to the court why that case is distinguishable from the facts of the present case. So the case in Locklear, the facts are similar between the indictment and the jury instructions in this case, but they're not the same. And one key difference in the jury charge in this case, as opposed to Lockwood, is that the charge narrowed the scope of the indictment to an oral statement as opposed to a written or oral statement. The jury charge was an oral statement made for obtaining a benefit under an insurance policy. So as opposed to the Lockwood case, in this case, there's actually less chance of jury confusion when you're saying only those oral statements made to the insurance company. The jury could not just consider every statement made by the defendant to convict the defendant on that charge, on the insurance fraud charge. So it's important then to consider what were the oral statements made to the insurance company, and that was defendant's oral recorded statement made to the State Farm investigator. She took a recorded statement, an oral statement, in which defendant makes misrepresentations and mischaracterizations as to the cause of the fire being accidental. So there's no chance of jury confusion if that's the statement that was alleged to be the insurance fraud. So, but the most important distinction between Locklear and this case is the fact that Locklear, there's no reference to a confession. In this case, we have a confession by the defendant, and I think that goes to the plain error analysis of this case. Even if there was error in the charge as read, which the state contends it's not because there was no fatal variance, there can be no prejudice or no likelihood of a different outcome because the defendant admitted to causing the fire. There's no likelihood that had the jury been instructed differently, the outcome would have been different because there's compelling evidence in this case and not in the Locklear case of defendant's guilt. So for these reasons and for the reasons contained in the brief for the state requests that the court uphold defendant's convictions for all charges and find no error on the part of the trial court for the first 3 issues raised. The state requests that the case be remanded to the trial court for a new hearing and resentencing on the issue of restitution only. Thank you.
All right, thank you, counsel. Any rebuttal?
Yes, Your Honor, thank you. At its core, this case is about observing the definitional parameters of a common law crime that have been settled for centuries. The state had total and complete discretion determining what offenses to charge in this matter. It was the state's election to charge specific offenses of second-degree arson and conspiracy to commit second-degree arson. And we contend that those charges meet the facts of this case like a square peg meets a round hole. It simply does not fit. And the state makes the contention that the fact that that these were co-conspirators as opposed to co-defendants is dispositive. And we contend that that is, for purposes of this case, a distinction without a difference, because the co-conspirator, Ms. Turner, was specifically charged with conspiracy to commit second-degree arson. And for the reasons that we argued previously, that simply cannot be the case. Now, with respect to the 702 argument, the state essentially seeks to have it both ways. The state claims that Silver's testimony was proper because they claim it was based on the scientific method because, well, Silver said it was based on the scientific method. But that is not it's not for the witness to tell us whether or not Rule 702 is satisfied. It's for the trial court to make that determination based on the factors set forward in 702 and Dalbert and McGrady. And on the other hand, the state also says, well, any deviation from the NFPA 921, which is and recommends the scientific method, is not the standard by which to judge the admissibility of expert testimony. Well, I don't think the state can have it both ways. And the NFPA 921 is the authoritative gold standard. It's the standard of care recognized by jurisdictions all around our country as to what to look for in terms of determining the reliability of fire investigation methods. And it explicitly says that it repudiates negative corpus. And so we would contend that it was a reliable and relevant factor to consider in determining whether or not the testimony satisfied Rule 702. And that it would be permissible for this court to consider it on appeal. It was discussed during the hearing, during the trial, and the court can also consider the other authorities that we've raised, secondary sources, law review articles that we've attached to the brief, as this court routinely does in other cases in which we've cited examples of which in our brief. And that the fact that those ones specifically weren't cited to the trial court, we think is not dispositive. It's like saying you can't argue the same cases on appeal. You can't argue new cases on appeal that weren't specifically argued to the trial court or cited to the trial court. I just don't think that's the case. Finally, we would contend with respect to the insurance fraud charge, since the state did discuss it, that it did constitute plain error to not instruct the jury on the specific misrepresentation that was alleged in the indictment based on the Locklear case. And for all of the reasons that we've argued in our briefs and that we've argued here today, we would ask this court to, in the first instance, vacate and dismiss Ms. Lance's convictions under the first argument, and the alternative to vacate her convictions and grant her a new trial under the second and third arguments. Thank you.
All right, thank you, counsel. Mr. Soar, we'll adjourn.
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
All right, thank you both. You're free to drop off now. We appreciate your argument. Thank you.
Thank you.